Title: The New York City Mayor's Office for People with Disabilities, the New York City Department of Cultural Affairs, and Art Beyond Sight present Project Access New York City, Best Practices for Inclusion in the Arts, Thursday, May 2, 2013, the Museum of Modern Art. Title: Access Law Updates and the Definition of, quote, reasonable accommodations, unquote. Panelists are Nick Williams, Senior Partner at Clifford Chance and Board Chair of Art Beyond Sight, and Ed O'Callahan, Partner at Clifford Chance and former Assistant U.S. District Attorney for the Southern District of New York. O'Callahan is seated at a table on a stage in an auditorium. Williams stands at a podium to the right of the table, and he speaks first.
Thank you all for coming. This is a fabulous turnout. I am the chairman of the board and proud to be the chairman of the board of Art Beyond Sight. Before I begin, I want to say a couple of big thank yous. First to the Museum of Modern Art for hosting today. Francesca, Glenn, what a great day, and thank you for having us. Second, thanks to the New York City's Department of Cultural Affairs and the Mayor's Office for People with Disabilities for taking the initiative in making the cultural riches of our great city accessible to all people. Jason, you've been a huge supporter of ours and I think a fair and reasonable proponent of access in your dealings. The topic today is accessible arts and culture. This morning we will talk about making your programming and your institution as accessible and inclusive as possible to all people. Here are three good reasons to do that. First of all, it's necessary. Well, we're going to be talking in detail in a few moments about the legal implications of accessibility, but suffice to say, it's something you have to do. Second, it's the right thing to do, ethically. I think we can all agree on that. And third, and I think Jason mentioned this, it's good for business. It can build your audience, your support base, and your revenue. The word disability covers a broad spectrum. If you use a wheelchair, you have a disability. If you wear reading glasses, and the only reason I'm not is because I've got this in large type, you also have a disability. Disability used to be defined as a medical condition. Not anymore. Now we look at disability as a part, what it means to be human. You have a disability if you need an accommodation of some sort, and to provide that accommodation, some barrier must be removed. The barrier could be physical, like steps you can't climb, but it can also be intellectual, cultural, or educational. There are 56 million Americans with disabilities today. It's the largest growing minority in the country. And with the baby boom generation entering retirement, the numbers will only grow. But any one of us can join this minority at any time because of sickness, accident, or just growing old. So, what does access mean? One way to start looking at this issue is by examining a law as it relates to accessibility. And for this, I would like to introduce Ed O'Callahan. Ed O'Callahan is my partner at Clifford Chance's litigation and dispute resolution practice in New York, with extensive litigation experience in civil and criminal matters, both in private practice and in governmental service. His practice focuses on defending organizations and individuals in international and domestic regulatory investigations and criminal prosecutions, including cases involving allegations of securities fraud, bank fraud, money laundering, accounting fraud, and numerous other fraud-related activities. From 1999 through 2008, Ed was an assistant United States attorney for the Southern District of New York and co-chief of the Terrorism and National Security Unit during the last 3 years of his tenure. He acted as the lead prosecutor on a number of high-profile matters, including the Department of Justice's international financial fraud investigation and prosecutions related to corruption in the UN's Oil for Food program, RICO prosecutions of organized crime families, numerous banks, and securities fraud cases. Ed is a 2008 recipient of the U.S. Attorney General's Award for Distinguished Service and the 2000 Director's Award for Superior Performance as an Assistant U.S. Attorney. He received his Bachelor of Arts in Government from Georgetown University in 1991, where he graduated with honors, and a J.D. from New York University School of Law in 1994. Following law school, Ed was law clerk to the Honorable Kevin Thomas Duffy, United States District Judge for the Southern District of New York. Ed, thank you. And ladies and gentlemen, let the games begin.
A lot of this is just common sense and how you can work within the parameters of the requirements of the ADA to reach a reasonable accommodation and provide access to the various members of the population with the various disabilities that we run into. I mean, it really is the governmental entities that are charged with the responsibility for enforcing the ADA really do want to work with the institutions, because it's not anyone's intent to close the door of any culture institution because of the fact that they are trying to reach a reasonable accommodation under the ADA, but rather make it more accessible to more people. And so I think that's something to really take heart to. And just to amplify the point of some of the common sense applications of this and how it's come out in some of the cases that we have seen, I think it would be interesting to learn about some of the cases. For instance, the Metropolitan Opera Consent Decree, which the Southern District of New York entered into back in 2011. It was principally a wheelchair access case, but one of the kind of common sense additional components of that was that in their review, they found that the Metropolitan Opera didn't have a visual alarm system in place. And that obviously creates some safety concerns. We want to have our cultural institutions be safe for everyone that is attending. And so one of part of the consent decree that if you do go on the website and take a look at, you'll see that the Met also agreed in place of installing a full visual alarm system, they agreed to use their already in place Met title system to display emergency information. To have members of staff inspect all areas accessible to the public in the event of an emergency. Now, that's just common sense, and that's utilizing a system that's already in place so that people can enjoy and be sure that they are safe in their enjoyment of those places. And then some of the other things that I'd like to point out is in addition to wheelchair access, obviously some of the agreements that have been entered into also take into account assistive listening systems that are key, and they go beyond New York, if you could imagine, and they go beyond traditional ideas of the cultural system, the cultural institution. And one of the cases that I will just mention is the Quicken Arena in Cleveland. In Cleveland, the DOJ entered into a fairly comprehensive voluntary settlement agreement just in December of 2012 with the operators of the Quicken Arena. That consent decree is interesting because it does focus on ensuring full access for deaf and hearing impaired patrons. And it's a pretty broad and encompassing agreement where the operators of Quicken Arena agreed to provide methods of effective real-time communication for patrons seeking to contact the arena, being text, telephone access. They agreed to ensure that visual messaging is used on scoreboards and video monitors to provide emergency information, much like the Met Opera. They take steps to provide equal and meaningful access to all oral information provided over public address systems, and again to acquire 233 fully functional receivers for assisted listening systems and make them available to patrons. Again, that's just an example of now the Cleveland Cavaliers have the capability to welcome fans because they have adopted these procedures under this settlement with the Department of Justice, whereas those fans would not have bought tickets to a Cleveland Cavaliers game if they couldn't enjoy the experience as much as they can now. I think, again, there's another example just quickly that I will address in Cheyenne, Wyoming, in the Taco John's Event Center. This is a municipal operated center where the Taco John's Event Center agreed through a settlement to remedy ADA access violations that they found. And in addition to the wheelchair access, they also agreed to provide assistive listening systems for 4% of the total seats in the audience. And I think that that again is just a show of how the reasonable accommodations can be made. One area that I think is interesting to touch upon, if we have a few more minutes, is in our internet-based business these days, much of your advertising, I would imagine, is done through websites, and your advertisements for upcoming programs, and just exactly what you can do is put on your website. And there's actually an interesting state of the law as to whether or not websites are considered sites of public accommodation. And in that Cleveland Cavaliers Quicken Arena settlement, the Cavaliers agreed to ensure that the website for their team and the Quicken Arena was accessible for blind patrons. Now, again, they would have to work with the government agency that was going to enforce that settlement agreement to just come up with what a reasonable accommodation on the website would be, but they've already agreed to do that. One, I just want to bring to your attention, lawyers always like when we can bring circuit court splits. That's the appellate courts in the federal system, because a circuit court split means that there might be an area of law that might actually be heard by the Supreme Court. And we have that here. And one area in the ADA enforcement is this website area, and whether the website can be considered a place of public accommodation for purposes of the ADA. And what we've seen is that certain circuits that have addressed it, for instance, the Ninth Circuit, is that they, I'm not going to say the case names, but I'll just say the Ninth Circuit's in California. They've held that a place of public accommodation is limited to an actual physical place, and therefore the website access is not considered an area of public accommodation. However, in the First Circuit, which is Massachusetts, generally speaking, and the Seventh Circuit, which is generally Chicago, they have held, or at least noted in portions of decisions, that public accommodations are not limited to physical locations, and they can accommodate, and public accommodation can encompass facilities and electronic space. That is just an interesting area of the ADA that is ripe for continued judicial scrutiny, and I think that is an area that will even further progress because it is a critical component of any institution's advertisement. So if you have a website, even though there is a circuit court split, it probably is a good idea to consider how you can make that readily accessible under the ADA if you are ultimately going to make sure that your institution is compliant.
Susan Rao, advisor to Art Beyond Sight. Would appreciate the perspective in terms of how the senior management and trustees of cultural and public entities that could be considered sports, culture, how they should be thinking about accessibility. Is this a core risk topic? Is it a marketing topic, a sales topic, operational? Is it solely a legal topic? What's your thinking in terms of how management and board should begin to think about access?
I mean, my quick response is all of the above, no doubt. It is no secret that certainly in the sports arena and those types of activities that the economy has had an effect on the ability of them to sell out their seats. I mean, it was unheard of, right? Not too long ago, for Yankee Stadium, Madison Square Garden, not to be sold out. Well, now that's a reality that they're dealing with, and I think that clearly providing more accessibility to those with the various disabilities that we're talking about just gives them another pool of potential audience members. And again, as everyone has been saying, it's just the right thing to do. So I think that they should understand that. And frankly, they do. I think the concern comes where they really do have a concern that essentially once they do start making reasonable accommodations in either structural or as required or in their ticketing practices or what have you, when you're going into program content, that is the area that they have had a little reluctance. And again, I think you'll hear throughout the course of the day that the idea of a reasonable accommodation also goes to program content. There's no one that is on the side of accessibility that is promoting the taking over of a cultural institution's program content. What we're hoping to achieve is a reasonable accommodation with that program content that somehow accommodates or maybe even will cater to a segment of the population that is inclined to utilize the services of that particular institution. So I think that's where I think some board members and some senior operators of the institutions might have more reluctance. There's always going to be the issue of the monetary cost of something, and frankly, I think that's something that is relatively at least concrete, right, to be able to work through. When you're talking about program content, I think it's a little bit more difficult of an issue.
Title: www.projectaccessforall.org. Copyright Project Access for All, 2013.